and having to tell her that other 9-year-olds were just killed in a shooting is horrific.
Today for the most significant law to be passed since then, for the last 30 years.
Field background checks could stop a lot of illegal guns going in different places in the country.
This shall not be infringed, and the word infringe means by banning parts on firearms actually is against the Constitution.
Affect us here, and it was such a breath of fresh air for the Second Amendment people.
It takes extraordinary courage for them to stand up here and retell the story.
Suppressors are currently subject to additional regulatory burdens under the National Firearms Act. The HPA would remove suppressors from regulation under the NFA and replace the overly burdensome federal transfer process with an instantaneous background check through the National Instant Criminal Background Check System. This process would make the purchasing and transfer process for suppressors equal to that for a rifle or shotgun. Supreme Court ruling upends lower court gun laws. A landmark U.S. Supreme Court decision on the Second Amendment is appending gun laws across the country, dividing judges and sowing confusion over what firearm restrictions can remain on the books. The High Court's ruling that set new standards for evaluating gun laws left open many questions, experts say, resulting in an increasing number of conflicting decisions as lower court judges struggled to figure out how to apply it. The Supreme Court's so-called Bruin decision changed the test that lower courts had long used for evaluating challenges to firearm restrictions. Judges should no longer consider whether the law serves public interests like enhancing public safety, the justices said. Under the Supreme Court's new test, the government that wants to uphold a gun restriction must look back into history to show it is consistent with the country's historical tradition of firearm regulation.
Today, we say more than enough. We say more than enough.
No Democrat has ever tried to get anybody's guns. I mean, that's just a lie that they tell, and y'all ought to stop perpetuating the lie.
We can reach compromise on guns. We ought to be able to reach compromise on other critical issues, from veterans' health care.
To have their firearms, which are being held by the government, transferred to a third party for the third party to sell.
Atlanta, Buffalo, Uvalde. And for the shootings that happen every day in the street that are mass shootings we don't even hear about.
Courts in recent months have declared unconstitutional federal laws designed to keep guns out of the hands of domestic abusers, felony defendants, and people who use marijuana. Judges have shot down a federal ban on possessing guns with serial numbers removed and gun restrictions for young adults in Texas, and have blocked the enforcement of Delaware's ban on the possession of homemade ghost guns. In several instances, judges looking at the same laws have come down on opposite sides on whether they are constitutional in the wake of the conservative Supreme Court majority's ruling. The legal turmoil caused by the first major gun ruling in a decade will likely force the Supreme Court to step in again soon to provide more guidance for judges. According to Jacob Charles, a professor specializing in firearms law at Pepperdine University's law school, there is confusion and disarray in the lower courts due to the inconsistent application of the methodology outlined in the Bruin decision. Different courts are reaching different conclusions and employing varying approaches to the interpretation of the Second Amendment. Charles points out that this inconsistency has resulted in the striking down of not only new firearm laws, but also long-standing laws that have been in place for decades. Prior to the Bruin decision, courts were generally unanimous in upholding the constitutionality of these laws. The lack of consensus among lower courts regarding the application of the Bruin decision has led to uncertainty and a fragmented landscape in firearms law. This divergence in interpretation has significant implications for the legal framework surrounding firearms regulations. Legal challenges amid rising gun violence. The legal wrangling is playing out as mass slayings continue to plague the country awash in guns, and as law enforcement officials across the U.S. work to combat an uptick in violent crime. 6 people were fatally slayed at multiple locations in a small town in rural Mississippi, and a gunman slayed 3 students and critically wounded 5 others at Michigan State University before ending himself. Dozens of people have died in mass slayings so far in 2023, including in California, where 11 people were slayed as they welcomed the Lunar New Year at a dance hall popular with older Asian Americans. Last year, more than 600 mass slayings occurred in the U.S., in which at least 4 people were slayed or wounded, according to the Gun Violence Archive. The decision opened the door to a wave of legal challenges from gun rights activists who saw an opportunity to undo laws on everything from age limits to AR-15 style semi-auto weapons. For gun rights supporters, the Bruen decision was a welcome development that removed what they see as unconstitutional restraints on Second Amendment rights. Mark Oliva, a spokesman for the National Shooting Sports Foundation, stated that the Supreme Court's decision provides a true reading of the Constitution and the Bill of Rights, offering clarity to lower courts regarding the application of constitutional rights. Gun control groups are expressing concern following a recent ruling by a federal appeals court. According to the court, under the new standards set by the Supreme Court, individuals with domestic violence restraining orders cannot be prohibited from owning guns by the government. The Fifth U.S. Circuit Court of Appeals in New Orleans acknowledged the protective goals of the law in place to safeguard vulnerable individuals in society. However, the court concluded that the government failed to demonstrate a comparable historical precedent from early American history. Attorney General Merrick Garland has expressed the government's intention to seek further review of this decision. Gun control activists criticize the Supreme Court's historical test, but express confidence that many gun restrictions will withstand legal challenges. For instance, judges have consistently upheld the federal ban on convicted felons possessing guns since the Supreme Court's ruling. The Supreme Court recognized the cases involving unprecedented societal concerns or significant technological advancements may necessitate a more nuanced approach. The justices emphasized that the right to bear arms is limited to law-abiding citizens, according to Shira Feldman, litigation counsel for Brady, a gun control group. Judges' interpretation of historical laws. The Supreme Court's test has raised questions about whether judges are suited to be poring over history and whether it makes sense to judge modern laws based on regulations, or a lack thereof, from the past. Mississippi U.S. District Judge Carlton Reeves, appointed by President Barack Obama, expressed the view that judges are not experts on the thoughts of white, wealthy, and male property owners regarding firearms regulation in 1791. He criticized the expectation for judge to play the role of historians in constitutional adjudication. According to Andrew Willinger, the executive director of the Duke Center for Firearms Law, some judges closely analyze historical laws and argue that they are not analogous to modern laws due to slight differences in their functioning. Other judges take a more flexible approach, attempting to understand the purpose of historical laws to the best of their ability. Firearm rights and gun control groups are closely watching many pending cases, including several challenging state laws banning certain semi-auto weapons and high-capacity mags. A federal judge in Chicago denied a bid to block an Illinois law that bans the sale of so-called attack weapons and high-capacity mags, finding the law to be constitutional under the Supreme Court's new test. A state court, however, already has partially blocked the law, allowing some gun dealers to continue selling the weapons amid a separate legal challenge. Already, some gun laws passed in the wake of the Supreme Court decision have been shot down. A judge declared multiple portions of New York's new gun law unconstitutional, including rules that restrict carrying firearms in public parks and places of worship. An appeals court later put that ruling on hold while it considered the case, and the Supreme Court has allowed New York to enforce the law for now.
I don't have a gun, but I don't give a damn about anybody else having one.
The most serious readily provable offenses in cases where mandatory minimums are present because it's not warranted.
Giving domestic violence abusers a license to kill and essentially preventing the government from doing anything at all about it.
What changes that item that was submitted was not produced and was not the item that was marketed.
The government quite properly charged him with several crimes.
The sensitive places doctrine was not at issue in this case and still exists.
Some judges have upheld a law banning people under indictment for felons from buying guns, while others have declared it unconstitutional. A federal judge issued an order barring Delaware from enforcing provisions of a new law outlawing the manufacture and possession of so-called ghost guns that don't have serial numbers and can be nearly impossible for law enforcement officials to trace. But another judge rejected a challenge to California's ghost gun regulations. In the California case, U.S. District Judge George Wu, who was nominated by President George W. Bush, appeared to take a dig at how other judges are interpreting the Supreme Court's guidance. The company that brought the challenge, and apparently certain other courts, would like to treat the Supreme Court's decision as a word salad, choosing an ingredient from one side of the plate and an entirely separate ingredient from the other, until there is nothing left whatsoever other than an entirely bulletproof and unrestrained Second Amendment, Wu wrote in his ruling. New Texas Suppressor Law. On June 17, 2021, Texas Governor Greg Abbott signed 7 Second Amendment-related pieces of legislation into law. These laws aim to protect the rights of law-abiding citizens and ensure that Texas remains a bastion of freedom. One of the most significant pieces of legislation is House Bill 957, which repealed the criminal offense of possessing, manufacturing, transporting, or repairing a firearm silencer. It also ensures that any firearm suppressor manufactured in Texas and that remains in Texas will not be subject to federal law or federal regulation. The new law removes the threat of state-level prosecution for unregistered suppressor manufacturing, sales, and/or possession, without providing any level of immunity from federal-level prosecution. This is similar to state marijuana laws, which can still be prosecuted under federal law. The bill is set up to set the Attorney General in Texas up for a test case, which will need to be carefully crafted to properly navigate all of the necessary legal channels. HB 957 prevents Texas state resources from being allowed to enforce the federal National Firearms Act with respect to silencers, suppressors, or gun mufflers. If any Texas official aids in the enforcement of the NFA in regards to suppressors, they are subject to losing any grant funds from the state for the following fiscal year. This incentivizes state-level law enforcement to disregard compliance with the NFA if they want to keep their funding intact.
But then it released him, apparently believing that a civil restraining order instead of pretrial detention was the best way.
He went on to say he looks forward to a quick resolution in the Texas Senate.
Predictably, Mr. Rahimi soon thought, to hell with your restraining order.
Who are prepared and carry a gun oftentimes have to make split-second decisions.
Aggravated assault with a deadly weapon against a different woman using a gun that he wasn't legally allowed to own, but obtained anyway.
The new Texas law is taking direct aim at the Constitution's Commerce Clause and how it is to be interpreted. A firearm suppressor manufactured in Texas and remains in this state is not subject to federal law or federal regulation, including registration, under the authority of the U.S. Congress to regulate interstate commerce. A basic material from which a firearm suppressor is manufactured in this state, including unmachined steel, is not a firearm suppressor and is not subject to federal regulation under the authority of the U.S. Congress to regulate interstate commerce as if it actually were a firearm suppressor. A firearm suppressor manufactured and sold in Texas must have the words "Made in Texas" clearly stamped on it. The Attorney General must seek a declaratory judgment from a federal district court in this state that Section 2.052 is consistent with the U.S. Constitution. This means that Texas-sourced raw materials needed to build a suppressor are not subject to federal regulation under interstate commerce because nothing is leaving the state. Limitations and options. The new Texas law aims to allow residents to purchase Texas-made suppressors without the lengthy NFA paperwork and $200 tax stamp. However, this law does little to facilitate the purchase process. Federal law only allows specially licensed FFLs to sell suppressors, and dealers must comply with all federal laws to maintain their licenses and avoid jail. Therefore, there is no legal way to buy a Texas-made suppressor from a dealer unless the dealer wants to put their livelihood at risk. To take advantage of this, Texas residents can build their own suppressors, which would typically be governed by a Form 1 instead of a Form 4. However, the ATF and federal law still require DIY suppressors to be registered and taxed with a Form 1, regardless of the state they are made in. Silencer Central offers assistance in navigating the silencer buying process, offering assistance with suppressor-related questions and helping individuals start their own journey towards suppressor ownership. They have been selling silencers for over 15 years in every state where silencers are legal. Texas Suppressor Freedom Case. The issue that we are addressing is known as Paxed Envy Dettelbox, and it is a significant and recent legal matter that focuses on the removal of the Arms Trade Treaty and the National Firearms Act regulations regulating suppressors. A couple of weeks ago, oral arguments for the opposing parties' applications for summary judgment were presented. The feedback received from the court indicated that the side that supported the Second Amendment did not have a successful outcome during these proceedings. However, the state of Texas has asked the judge for permission to supply more materials in support of their move for summary judgment by submitting additional briefs and a letter. This request was made after the state of Texas made a request to the judge. This request has been granted by the court, which paves the way for Texas to respond to the three primary issues that the judge posed at the hearings. This new turn of events is encouraging because it provides the state of Texas with a second opportunity to offer additional information in support of their position that suppressors made in Texas should not be subject to the restrictions imposed by the NFA. This action is a result of Texas House Bill 957, and the state of Texas is actively seeking to explain why a petition for summary judgment should be granted against the Bureau of Alcohol, Tobacco, Firearms, and Explosives in regard to the NFA regulations that affect suppressors created in Texas. Challenging ATF regulations. The Suppressor Manufacturing and Retention Act, also known as HB 957, is a law that was recently approved in Texas with the intention of exempting suppressors created and retained within the state from federal laws. The rationale behind this rule is that given that these products are manufactured and marketed solely within the state of Texas, they do not participate in interstate commerce and are therefore exempt from the ATF's authority to regulate them at the federal level. However, in response, the ATF stated that they would continue to enforce federal limitations on suppressors manufactured in Texas and take action against anyone who either manufactures or sells suppressors. In retaliation, Texas launched a lawsuit against the ATF, which ultimately led to the ongoing litigation.
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
I'm just inspired by the next generation. I think it's a time for a big change.
Since you rewrote the rules of asylum based on the perceived degree of violence in these countries.
Selling more guns in the last 3 weeks than we did in the last 8 months.
To be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs.
At a hearing that took place not too long ago in front of a federal district court, the state of Texas asserted in the original lawsuit that federal control of these commodities, which are created and kept within the state, is not permissible because it does not impact interstate commerce. In addition, they argued that the regulations imposed by the ATF on these articles constitute an unconstitutional levy on a constitutional right, as well as a significant violation of the rights guaranteed by the Second Amendment to residents of Texas. The most recent decision made by the Supreme Court in the case of New York State Rifle and Pistol Association versus Bruin has given Texas's argument additional support. This ruling reaffirmed that historical analysis, which is to be informed by the text in question, is the appropriate technique to take when assessing matters involving the Second Amendment. As a result of this, the ATF now has to provide a justification for the limits that they have placed on suppressors manufactured in Texas, using the analysis that was established in Bruin. In spite of the ATF's efforts to circumvent this duty by asserting that suppressors do not enjoy the protections afforded by the Second Amendment, the statutory definition of firearm does in fact include suppressors. This contradiction calls into question the ATF's regulatory power as well as the extent to which they have discretion in executing regulations. Definition and protection of suppressors. In the current legal dispute between Texas and the ATF, competing opinions concerning the classification and protection of suppressors has surfaced. The ATF contends that suppressors do not qualify as tolerable arms, as required by the Second Amendment for protection, and that the recent judgment of the Supreme Court in Bruin does not apply to this situation. On the other hand, Texas is of the opinion that the Second Amendment protects all forms of firearms that can be used for defensive purposes, including suppressors. Each party is confident in their capacity to prevail in this legal dispute, and as a result, both sides have filed cross applications for summary judgment. The fate of the case will be decided by the judge in the end. During the opening round of the debate, Texas placed a strong emphasis on the fact that the ATS's assertion that suppressors are uncommon and hazardous is false. The disagreement revolves over the interpretation and application of constitutional rights for various kinds of arms, in particular with regard to their effectiveness as tools for self-defense. It remains to be seen how the judge will decide on this subject, since the contrasting stances taken by Texas and the ATF underscore the diverse opinions on the definition of suppressors and the protection afforded to suppressors under the Second Amendment. Arguments in Suppressor Case. During the course of the hearing, Texas provided evidence in the form of remarks made by ATF leadership during the tenure of the Obama administration. These statements unequivocally established that suppressors do not inherently pose a risk. In addition, the data collected by the ATF show that there are about 2.6 million suppressors that have been registered in the U.S. This indicates that suppressors cannot be regarded as being particularly exceptional. It appears as though Texas had a strong case, given that they were armed with these solid facts, a recent ruling from the Supreme Court, and the advantage of having a favorable district court in Texas. However, the reports that came out of the session indicated that the Texas attorneys may have struggled when presenting their case in front of the judge. Nevertheless, this problem may have been resolved by submitting an extra letter and arguments to the court, which was granted permission to be considered. The purpose of this supplemental filing was to respond to the three primary questions that were posed by the court while the hearing was taking place. The letter started off by addressing a question about standing, which was the first question. Texas aimed to establish its legal right to dispute the ATF's regulations on suppressors and contended that their interests as a state are directly affected by the federal limits. In doing so, Texas intended to establish its legal right to challenge the ATF's regulations on suppressors. There is a good chance that the letter elucidated Texas's stance and offered additional support for their argument in the case. The answer of the standing question and the overall strength of Texas's arguments will play a critical role in establishing the path that the suppressor case will go as the hearings continue. Anti-Injunction Act in Suppressor Case. In a letter that was sent to the court, Texas argues for standing in its constitutional arguments against the federal regulation of farm suppressors without needing plaintiffs to expose themselves to the procedure that is being argued to be unlawful. This was done so that they can challenge the constitutionality of the federal rule. As evidence in favor of their viewpoint, they cite the recent ruling that the Supreme Court rendered in the Axon case. In its response, the ATF asserts that the plaintiffs do not have the legal right to bring this case, since they have not provided the ATF with suppressors manufactured in Texas for NFA approval. The state of Texas contends that the most recent judgment from the Supreme Court exempts them from the obligation of adhering to an unconstitutional method, which establishes their standing as a party to the case. The second thing that needs to be taken into consideration is whether or not the Anti-Injunction Act prevents the court from preventing the implementation of the National Firearms Act, owing to the fact that it is related to taxes. The ATF contends that the AIA prohibits the court from rendering a decision on this issue because such a decision would make it more difficult to evaluate and collect taxes. However, Texas believes that the AIA is not applicable in this case, since their lawsuit wants to dispute the implementation of statutes, regulations, and duties that extend beyond basic taxing requirements. Texas's argument is based on the fact that their lawsuit attempts to challenge the execution of such statutes, regulations, and obligations. They contend that the problem at stake goes beyond what is covered by the AIA in its entirety. Texas cites the Bruin judgment in an attempt to answer the question of whether or not farm suppressors fall under the definition of arms. The court that heard the Bruin case gave a broad interpretation of arms, which included modern tools that make armed self-defense easier. According to the state of Texas's interpretation of this criterion, therefore, farm suppressors should be regarded to be firearms. In the continuing suppressor dispute, these points concerning standing, the AIA, and the designation of farm suppressors as arms are significant aspects that are influencing the tenor of the court proceedings. Additional arguments to bolster case. A recent letter to the court from the state of Texas requested permission to provide additional arguments in support of their claims. The court agreed to grant this request. This is an evidence in their defense of the reasons why a summary judgment motion should be granted in their favor.
The uptick in violence has just been astronomical. The gun violence.
Pretty clear about the extent to which this is an abuse of the Administrative Procedures Act.
Is it a difficult question to understand? Well,
I'm sure it's enormously high.
It's 36 per 100,000 people.
I just felt that I needed to be able to protect myself.
The court had already acknowledged the historical inclusion of armament for defense under the definition of terms, indicating that the definition is not restricted to completed weapons. This finding indicates that the definition does not apply just to finished weapons. Even while the Supreme Court did not directly identify farm suppressors as modern equipment that allow armed self-defense in its recent decision in Bruin, the presence of farm suppressors as such devices helps Texas's claims. It is the purpose of this letter to buttress their points and provide additional evidence for their case. The preliminary results of the hearing did not look good for the pro-2A side, which is why this letter is such a critical opportunity for Texas to strengthen their argument. The extra reasons that were offered in the letter were written with the intention of addressing any deficiencies that were brought to light during the hearing and eventually leading to the state of Texas being awarded a summary judgment in their favor. As a whole, the decision of the court to grant Texas permission to submit this letter is regarded as positive news, since it provides Texas with the opportunity to bolster their case and increases the likelihood of a successful conclusion in the form of a summary judgment. That's all for this video, folks. See you next time.